Hello, everyone. Am I audible and visible?
Yes, Arpita, you are.
Okay.
Yes, you are.
Uh, Param sir, do we have you here? Can you check if your camera and mic is working properly?
I hope you can see me.
Yes, sir.
Thank you.
That being said, with your permission, may we start the session?
Please, please.
Good afternoon, everyone. Good afternoon, sir. I'm Arpita Chaudhary. I'm a second year student and a proud member of Chanakya Center for Alternate Dispute Resolution. I extend a warm welcome to each and everyone present here today who have chosen to spend their valuable weekend with us in this session. At CCADR, we are committed to enhancing awareness and understanding in the field of alternative dispute resolution, and for the same, we have hosted several guest lectures, one of which we are hosting today here. It is my great pleasure to introduce our distinguished guest for today's lecture, Mr. Param Bhamra. Ankita, can you introduce? Ankita, you
Ankita,
are
you are
muted.
muted.
Am I audible? Am I
Yes,
audible?
yes,
Yes, you
yes,
are.
yes. Go on, go on.
Thank you so much. Hello, everybody. I am Ankita, and a second year student and a proud member of CCADR. I would like you to introduce Param sir that what his work has been till today. Today, we are honored to have you, sir, with us to shed light on career opportunities in the realm of ADR because you have a great expertise in this. Because sir is founding member, founding partner at Mediate Guru, and a seasoned professional with wealth of expertise and specialization in the realm of international arbitration. Sir actively speaks on and contribute to the elevation of legal skills and knowledge among emerging law students. Sir is very specialized in international mediation and arbitration, and sir also have a literary portfolio, and sir have authored over a dozen books and numerous publications, which are not only featured in national but also international journals. Sir also contributes to the society in a very exemplary manner, and sir has also received award from the NGOs for his dedicated work in the best interests of community. Sir has worked so much for providing educational opportunity to the underprivileged children. Sir, we are really very excited to have you here, and we cannot wait for our students to learn from you and your experience because you have a great experience, and we have this opportunity to learn from your experience. Thank you so much, sir. Uh, sir, you can take over.
Thank you, Ankita. That was quite an introduction. I feel like I'm a bit short. So, thank you for that. I hope I'm audible and visible to everyone.
Yes, sir.
Yes, sir.
Perfect, perfect. So, once again, hello to all CNLU students, and it is my pleasure to be here. And thank you, everyone, to be here on a Sunday, that to an afternoon. I know if I was in my law school, I wouldn't have been attending any events on a weekend, that's for sure. But thank you all for coming here. Uh, so the topic we have today is careers in ADR. I can assume you guys know what's ADR. Can people raise their hand if they know what's ADR? So five people know what's ADR. Now that's interesting. We can go over the basics of ADR. It's not a problem. So ADR is alternative dispute resolution. That is, it provides for a alternative, as the name stands. It provides for an alternative method of resolving the dispute. Let's say, sorry, Ankita, let's say if I had a fight with Ankita, let's say that she had to pay me 100 rupees, but she's not paying me. So either I can take her to court that, Ankita is not paying me, so I'll sue you. I'll sue you in the court. So, we'll go over that in a bit. That I'm pretty sure you guys know there's pendency of cases, there's huge time constraints. So it's very hotspot. So the ADR methods, it's efficient. We have your arbitration, we have your mediation, there's conciliation, there's negotiation, there's adjudication. For today, we will focus on arbitration and mediation because practically that's what I deal with. I don't claim that I'm an expert of negotiation, adjudication, or conciliation. So let's try to not go there, or else I'll feel embarrassed. I hope you guys don't want me to feel embarrassed. Yeah. Thank you. So, why ADR? All right, I'll ask you a question. Who here has, in past couple months, saw on the news that Bar Council of India has allowed the entry of foreign firms in India? Anyone? You can raise your hands. All right. So I'll assume that most of you have heard. So you guys must also know that the foreign lawyers cannot just go to your any court and litigate on any manner. Let's say if you have a property dispute or if you have a divorce dispute or criminal dispute whatsoever, no foreign lawyer can just go and represent. For that, foreign lawyers can only practice uh, in advisory manner for either international law or for arbitration. Now, why do you think that Bar Council of India allowed the entry of foreign practitioners in arbitration? Anyone want to make a guess? Yeah, it's pretty tricky, so don't worry if you don't get there. The point is, uh, we are currently in a golden age of arbitration. The arbitration is gaining more and more traction. Mediation is not far behind, but arbitration is getting more fame as of now. If any of you have ever done any corporate internships, maybe with firm or you were part of some contract drafting team, you guys must have noticed that almost all contracts have arbitration clause in it. Not mediation, nothing else, but arbitration. Why? Well, first of all, it's efficient. Arbitrators will give the 100% to get your dispute resolved. I have seen arbitrators working on Saturdays and Sundays. I have seen arbitrators working on 1st January, 31st December, 15th August. They won't take any day off. I mean, if they want, that's always up to them. But the point is why? Anyone want to make a guess? Maybe write in chat box and wait for 10-15 seconds. Or if you guys can turn your mic on, you can also do that. Let's make this interactive. Let's talk. All right, I'll just go ahead. So the point is, arbitrators get paid. If you tell them that be available on Sunday, they will be available on Sunday because the client will be paying them. On the other hand, judge, you're not paying judge anything. Judge will take their leave. Judge will decide on a manner in 5 or 6 minutes and away you go. If you want next date, you will get next date. There's nothing keeping judge there. So it's efficient. If you go to traditional litigation, your case might get resolved in 3 years, 4 years, 5 years, God knows. If you go to arbitration, your case will likely get resolved within 6 months to 12 months. Further, it's supposed to be cheap. That again depends. Arbitrations are comparatively expensive. Mediations are very, very, very cheap. I will come to the cost factor in a bit, but remember that still compared to litigation, arbitration can still be cheaper. Further, why do people want to go to ADR? ADR provides a sense of control. You have your fate in your hand. Let's say if I go to court for my any dispute, basically I am giving all of my control to the judge. Judge will decide on my behalf. But what if I want to have that control in my hand? I want to see, how I want my case to work out. In litigation, I can't do anything in front of the judge. My entire fate is in judge's hand. But in mediation and in arbitration, to some extent, my fate is in my hand. I can still have a say in how my fate will turn out. If you see around 50 years ago or even 40 years ago, for anything, for any dispute whatsoever, you will go to court, not arbitration, not mediation, you will go to court. See, because we lived, we do live in a patriarch society. Now I'm not coming to male versus female, just in traditional patriarch society that there's a elder in our home or there's a elder in our village or city or the community we live in. So basically, what I believe, this is my opinion. What I believe is we have a tendency to give out our decision making to our elders. We don't want to make decision which what do we say, which will do something for us. In mediation, in arbitration, our fate is in our hand. But if we go to court, suddenly we don't have that accountability. If we mess up anyhow, if we, after 2 years, 3 years, 4 years, we look back and see that agreement we signed, that arbitration award or the mediation agreement, we were wrong. But in case of judiciary, we'll just say, judge did what he thought best. We had no control over it. So that means we are not accountable. So that was a problem. And like we are currently developing, I'll come to that again. The part is, if you think about it, I'm pretty sure there must be BA, LLB students here as well who have did their political science and sort of economics as well. In 1991, we went over liberalization, privatization, globalization. So what we did is basically our economy got collapsed. We had, we had enough funds to run our country for 3 more months or 3 more weeks. What we needed was foreign investments for our economy to sustain. So they wanted us to open up our economy. So how will, you know, let's say a foreign investor comes, they will invest in Indian economy. Let's say, Microsoft comes. Microsoft will start, they'll buy a plant for a factory, start manufacturing in India. But what if Microsoft runs into a dispute with their landowner or with someone who supplies them raw material? What will happen then? Because traditionally, if they go to court, the courts will uh, be bit biased to Indian party rather than foreign party, even if they are not biased. And but the Microsoft company or any foreign investor will feel that Indian courts are biased in favor of Indian parties. So what to do then? That's when Arbitration Act came in 1996, that private parties or foreign investors can go directly to arbitration without having any compulsory provisions to go to Indian courts. And as we can see, after that, Indian economy took a huge boost, and we are currently on our way to be a $5 trillion economy. And to achieve that, we got our mediation bill passed last year. You will see government is doing amendments to Arbitration Act regularly. So the whole point is government is promoting arbitration. Hence, BCI also allowed the entry of foreign lawyers in arbitration, because I personally believe ADR is the future. Because you guys must have also know the difference between communism and capitalism, your political economic students. So see, the point is, what the point I'm trying to make is we are going toward privatization. ADR is nothing but sort of a private sort of court. Arbitration is just a private court. And if I were to take a poll right now, uh, if you in future, whenever you guys will get married, you guys will have kids, will you send your kids to a government school or a private school? I can assume you will send your kids to a private school. God forbid, if something happens to you, you will go to a government hospital or a private hospital. You'll go to a private hospital. I hope. Sorry, I hope nothing happens to you, but just for the sake of example. So see, that's the thing. ADR is a private court. You go to court, you'll get your time wasted. You go to arbitration, you go to mediation, you'll get your dispute resolved, you'll go back home. So I hope you guys now know the basic of ADR, mediation and arbitration. If you have any questions to this point, please you can turn your mic on, you can write in chat box. I'll wait for, let's say, 30 seconds. Should I assume there's no questions so far? Either I'm spinning very well, or either you are all sleeping. Anyway, so we'll proceed. So I'm now hoping you guys know the basic of ADR. So now how to make a career in ADR. So first, also depends what you want to do. Do you want to be a mediator? Do you want to be an arbitrator? Though both of them came in ADR, both of them are inherently different. They are pretty much very, very, very different. And I hope you guys know that. As I said, arbitration is same to same your court, except that you are paying your counsel and your arbitrator. It's same as litigation. In mediator, there's a third party who won't decide on your behalf, but who will help you get to decision. So, who can be a mediator? Anyone know? So you can just raise your hand if you know. You don't have to speak or anything. If you're feeling shy, don't worry. so that I can have a better understanding. Who knows? So can anyone be a mediator? Can our lovely moderators be mediators? Okay, so three people know who can be mediator. No worries. So anyone can be mediator. I have pretty good friends who are not even from law background who are mediators. Anyone, whosoever, can be mediator. Let's say if your two friends are fighting, you resolve their fight. Congratulations, you are a mediator. That's about it. As of now, well, see, you can be a mediator, but at the end, the problems comes to appointment, which we will go to arbitration as well. Let's say, again, I'm sorry, moderators, if Ankita and Arpita has fight over anything whatsoever. So, can I be mediator in that? See, it depends. If both Ankita and Arpita agrees on my name, they agree to appoint me as mediator, then I will be mediator. But let's assume Ankita and Arpita don't know me at all. I'm just a random stranger to them. Why will they appoint me? They have no reason to appoint me. So generally, they will go through my profile, or maybe they'll go through the Supreme Court's program committee, and they'll see who can be a mediator. In that report, in that mediation manual, they will see that anyone can be a mediator who has done at least 40 hours of mediation training. So if they see that, there's this guy, Param, he has done 40 hours of mediation training, then, he may be qualified. So we can appoint him. So that's a basic thing. Anyone can be a mediator who has received a 40-hour mediation training. Now you can get your mediation training from any high court. There are online platforms as such. We at Mediate Guru organize 40-hour mediation training as well. There is this DDRS, Delhi Dispute Resolution Services. You can go internationally. You can go from IMI. There is Singapore International Mediation Institute. So basically, you can go to any mediation organization. You can get a 40-hour mediation certificate, and then you can be a mediator. But now you have to see that let's assume you got your mediation certificate. You got a 40-hour mediation training. How will you get clients? At the end, either you go into law, either you go into corporate law, either you go into litigation, arbitration, mediation, whatsoever. At the end of the day, it's all about getting clients. Do you guys agree? We'll come to that. Don't worry. To be honest, let's talk about the money factor. Do you guys want to talk about the money factor? Okay,
Good afternoon, sir. May I ask some
please,
question about this?
please.
Sir, actually, I am Ayushi from BLLB course. Sir, actually, I want to ask that this is a bitter truth, but it is a truth that earlier people did not believe in this form of mediator. That if our family matters go to the court, then how can they concerned about it? Take an example of a stereotype family, like they do not want to that their family matters go to the court, and they do not also a person who hello sir, I am audible.
Yes, you are. Please go on.
So that how can we convince them that you have to go in court and dissolve this dispute?
Uh, See, going to the court is 50% of the problem we are facing. We want
Yes, sir.
people not to go to court, but to go to mediation, right?
Yes, sir.
And even if they go to court, there's a pretty much 100% chance that the judge will send them to mediation center before deciding anything, before doing anything. What we want is that people to not go to court direct, is for the people to go directly to mediation institute to try mediation first. And for that, mediation bill came last year only. It has pre-litigation mediation. That for any case, before going to court, you have to go to, you have to go for mediation before. And if it doesn't work out, then only you can register your case in in any court. Also, you raise the point that people don't like to go to courts for any family disputes. So see, in that case, how will the dispute be resolved? Let's say, uh, just for example, don't lean into anything. Let's say if I have a fight with my wife, all right. So it's a family matter. Now my family would want and her family would want that we don't go to court, all that badnami thing. So still, see, the fight will get resolved anyhow. It will either be, her parents and my parents would sit and help us mediate. At the end, it will be mediation only. I hope you can understand. Ayushi?
Yes, sir. Yes, sir.
All right. Thank you. Anything else? Anyone else? All right. So we will go to the cost factor. In India, in domestic proceedings, if you are a mediator, you can earn up to, let's say, 20 to 30,000 per case sitting as a mediator. Now the good thing is the mediations are over pretty quickly. Maybe some mediations are over in 2 or 3 sessions. That means you can earn 20 to 30,000 in, let's say, 1 week or 2 weeks. Again, that depends upon how you want to look at the world and what are your ambitions. The thing is, if you are getting your disputes resolved quickly, the chances are that you will get more clients. The more clients, that would mean that you are earning less, but you have more number of clients. So you have to do the math if you before going into any field whatsoever. Now, clients will come when you get empaneled as mediators with different mediation institutes or medications. I hope you mean mediations. Wait, wait, or what if someone further infringes? See, Amrit, what happens is whenever a mediation agreement is signed, just on the top of it, let's say me and you had a dispute. We worked it out in mediation. We reached a win-win scenario. One thing, sorry, the agreement is good for you, is good for me. So the overwhelming chances are that neither of us will try to violate it. Further, as you know, it's an agreement. Agreement is once signed is legally binding as a contract, and that was how it used to happen. But after mediation law came into effect last year, mediation proceedings and the mediation agreements are legally binding. Anyone else? Oh, Ayushi has also asked what are the cons of ADR. Well, truth be said, that's the first time anyone has ever asked me that question. The con I would say is that arbitration is very, 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 very expensive. If you're a client, that's a con for you. If you're going to be a lawyer, that will be a huge pro for you. So it will depend how you want to look at it. So we were talking about the cost factor. Mediation if you try to be a mediator, the salary is good, but I would say if you just go into litigation, 5 years, 10 years down the line, you will earn more than being a lawyer or an arbitrator or a counsel rather than being a mediator. But mediators, that their peace of mind, that the sense of achievement, that they actually did something good. I have met many, 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 many lawyers during my lifetime. And all right, I'll tell you one thing. When I was newly graduated, I went to Delhi High Court Bar Association to get my membership. So when I went there, one of the person, you have to get signatures of around 10 to 12 people to become a member. So I went to one of the member. I said, "Sir, can you please sign my form? I want to be member." So he said, "Yeah, sure, all right, sign." So he said, "Param, do you believe there's any justice in courts?" I said, "Yes, sir, sure. I mean, that's what we do. Lawyers are there for justice." He said, "No, we are here to take clients' money. There's no justice. So, don't live in a fairy world." Now I know some of you might not agree with that. I don't know if I agree to that, but it's still a thing. There's not always justice. But if you go into mediation, if you're a mediator, you can do justice. And that will be in your hand. It's self-fulfilling. You can sleep better at night. Yeah, that's about it. Tamanna Banerjee. Yeah, I'll get to your questions in a bit. So now we're going to. Anyone have any questions in mediation before I go to arbitration? Raise your hand if you want to ask, so I'll wait for you. All right, I'll just go ahead. So, before 2010 pre-litigation, 33, you can get 40 hours of training certified as a mediator, but a question is wrong. You are asking 0 years, 0 work experience in any law firm or associate, will I be considered a mediator? Yes, you will be considered as a mediator. But the thing is, law firms or any companies, they don't hire mediators. All right. So when you get certificate, you will be mediator, but no one hires mediators. No one hires arbitrators. Inherently, they are supposed to be neutral. If let's say, I work, for example, let's say if I'm a mediator and I'm hired by Khaitan. Now, let's again assume Pepsi is a client of Khaitan. Now, any mediation comes, any dispute comes, and I get appointed as mediator. Khaitan is representing, other party is, let's say, some other law firm. So, mediator and counsel will be from same firm, which violates neutrality. So, it will be biased. So, mediators and arbitrators are never hired. Ayushi, I could not understand your question. Can pre-litigation, can you please type it out? Are there any specific certifications or licenses? Uh, Devaki, I just said that you have to get 40 hours of basic training. You can get it from anywhere. You can just Google 40-hour mediation training, you'll find something. Sir, can we do mediation with practice? Of course, you can. You can do mediation anytime you want. Even if you are right now in your law school, you see two people fighting, you go, you get the fight resolved, you are mediator. Uh, let's go to arbitration. So, before 2019 amendment in arbitration, only lawyers and only graduates, only law graduates could be arbitrator. But recent amendment changed that fact, and now anyone can be an arbitrator. Anyone. You uh, you can do trainings. I think Indian Institute of Arbitration and Mediation organizes 25-hour arbitration training. You can get that, and then you can be empaneled as arbitrator. But the thing is, all right. So there is a conundrum in our legal field. That conundrum means, uh, okay, I'll get names from chatbots. Let's say Devaki and Manish had a fight. Well, not a fight. Let's say they are engaged in a business. They had an arbitration clause that if they have any dispute, they will go to arbitration. So now let's say a dispute arose between Devaki and Manish. So can I be arbitrator in that? You can type it out if you want. If both parties agree. Yes, yes. If both parties agree, then only. So now see the problem stands at, let's say that no, why Manish? Why do you think I can't be an arbitrator? You hurt my feelings, but please go on.
सर हम मतलब इस केस में हम कैसे मतलब फाइट है, इसमें कुछ भी हो सकता है, पर हम उस मतलब सिविल केसेस में हम आर्बिट्रेशन नेगोशिएशन में जाते हैं, मीडिएशन में जाते हैं.
No, no, I changed that. I said that if any dispute arose of any civil nature, then can I be appointed as arbitrator in the case?
Yes sir, but sir, if both the parties are agreed, then
Yes, yes. So see, the problem is, this is the inherent problem. Right now, if you are looking to hire an arbitrator for your dispute, you will find only former judges of High Court, former judges of Supreme Court. Because the arbitrator is just a judge who will decide between your dispute. Now, our justices, our honorable justices, they work in judiciary, then they get old, they get retired, but there is no retirement for private sector, right? In judiciary, you have to get retired at some time, but in private, there is no retirement. So what do? They get empaneled as an arbitrator. Now again, take the same example. Let's say again, Devaki and Manish has a civil dispute, and they have an option. Either they can choose me to be their arbitrator, or either they can choose some former justice of Supreme Court to be the arbitrator. What does everyone think they'll choose? Come on, guys. I'm waiting for your reply in the chat box. And meanwhile, no, Amrit, the knowledge of arbitration and conciliation that is not mandatory for mediation. Devaki, you are very sweet to say that, but not really no. Tamanna, you're right. In any case, given between the options, clients mostly go in favor of Supreme Court or High Court former justices because they have done arbitrations their whole life. Sorry, not arbitration, but their entire job portfolio was to decide on the basis of other people. They had done this thing for living. So in India, the problem is anyone can be an arbitrator as long as you can secure appointments. If Devaki want to appoint me, that's pretty nice, but the other party won't go for it. And again, in back of our minds, a judge is a neutral party. A judge, is not biased, whereas I, as a private person, may be biased. So people tend to go for justices, and this is a problem. Even our current CJI Device Chandrachud speaks on regularly on this, that arbitration industry is being clawed up by former justices. So what you can do is you can do ODR. We'll come to that. But before, should we talk on the cost factor of arbitration? How much you can earn? Yes, Tamanna, I will come to a question. Don't worry. I've seen that. So you guys want to know the cost, the profits you guys can earn? See, in Indian Arbitration Act, there's a limit on the price, on the fees an arbitrator can charge. But what I will suggest you is don't get limited to Indian arbitrations. Try to get, most of the international forms, most of the international organizations such as International Court of Chambers, there is Dubai International Arbitration Center, Singapore International Arbitration Centers. They empanel arbitrators and they empanel tribunal secretaries. I will come to tribunal secretary in a bit. So what you can do is get your empanelment from foreign organizations. You can work online. You can sit as an arbitrator. I mean, of course, you would need some experience before you will get appointments. But you can sit in India, in your home, and you can get appointments, and you can earn good amount of money. In foreign arbitrations, a person can get somewhat up to 10% of the entire dispute claim. Let's say if the dispute claim is $1 million, you can get straight away $100,000 from a dispute. Sir, from where we get our participation certificate? I'm not sure. Did you mean arbitration, mediation, or the event one? If event one, please get in touch with the organizers. Sorry, where was I? Yeah. See, even domestic you can do, but domestic will have a sort of fees constraint. But again, that fees constraint would be much, much higher than your mediation payouts. Most of the corporate firms go for arbitrations. Their dispute claims are in crores or hundreds of crores. An arbitrator will get a percentage out of it. So either way, if you can get even one dispute resolved in an entire year, I think you're good to go. So now the problem which I said, because all the judges are arbitrator, how will you get appointments? Anyone has any idea? Please write down in chat box if you want to, interact.
Sir, please repeat your questions.
Yeah, so as I said, I hope you guys have heard about the thing that people only prefer Supreme Court judges. They don't want normal people like us to sit as an arbitrator. So how can we make a career in arbitration? I mean, I know I'm the one here to give a lecture on that, but if you want to jump in, please go ahead. Yeah, don't worry, it's quite tricky thing. So see, have you guys heard about the judicial clerk? That we have judicial clerks in every courtrooms. I'm sure you must have heard. Making the fee low. Yeah, see, TC 33, if the fee is low, then you won't get anything as well. All right. So see, the reason parties or clients appoint senior Supreme Court judges or High Court judges is because they have experience, right? And let's say you just graduated last year and now you want to make a career in arbitration. Obviously, you don't have any experience whatsoever. How will we? Devati, you are absolutely right. Yes. I will come to that in a bit as well. I'm really enjoying the session. I made a lot of notes to say, but you guys are keeping all my time. That's amazing. So see, as I was asking, you guys know about judicial clerk. In every room, there's a courtroom officer. There's a clerk sitting in every courtrooms, taking down notes, making judgments, drafting judgments. Basically, they act as a secretary to the courtroom. Same way, you can enroll in a tribunal secretary programs. Even arbitrators need secretaries, administrative secretary. They need people who can, sit, who can make notes, and with that, you will get to work closely with the arbitrators. When you work closely with the arbitrators, you will get experience. Maybe couple year down the road, you will get enough experience that your CV will look good, and then you can send out your CVs. Let's say you were working with some former judge who used to handle cases of, let's say, 100 crore, 200 crores, and you have good experience with that. Then you can go to some lower regime, some 1 crore, 2 crore, 3 crore dispute amount cases, and they will see that you have managed cases of hundreds of crores. So there's a better chance that you will get your appointment in that case. Once you get your appointment, there's only uphill from that. You know, once you get your appointment, you are set. Hopefully, you will, arbitrate cases. There's a very good scope in arbitration. The pay is very good. Everything is good. But as Devaki said, that as of now, if you guys have read Arbitration Net, you guys must know that in arbitration proceedings there is no procedural law. Like we don't need to apply CPC to arbitration. I hope you guys know that, right? Because arbitration is supposed to be flexible. That whatever the parties want, it's party centric. But if there's some justice sitting on the other side of the table and lawyers are coming to argue for the client, judge will just say that let's follow CPC because judge has habit of it, and the lawyers arguing, even they know CPC, so it's not a big deal. But again, the arbitration is supposed to be an informal setting, but judges, former judges, make it a formal proceeding, which sometimes take a very long time. If you guys have an opportunity to observe an Indian arbitration and a foreign arbitration, you guys will see the difference. Foreign arbitrations are more and somehow similar to mediation. In foreign arbitrations, the arbitrator is loosely like they want the parties to come to a settlement. At every proceeding, at every hearing, the arbitrator closes with the statement that if you guys want to come to a settlement, just let me know. I will pass a consent decree. Consent decree is your basic mediation agreement. Whatever you guys mutually decide, the arbitrator will sign on it. But if parties fail to get on a compromise, then then the arbitrator will decide on their behalf. So uh, that's the benefit of making a career in arbitration. You won't get the sense of fulfillment you get from mediation but well, you get a lot of money. So I hope that's a plus point for few of the people. Another career scope is you can be a teacher. And I don't have anything more to say that. If you want to be teacher, good for you. Before getting to the questions, you guys can start writing your questions if you want in the chat box. The emerging fields in ADR is uh, investment arbitration. You know, let's say India signs a treaty with Dubai that we will do investments in each other's country, and some dispute arose. That dispute will be resolved by arbitration. And because the public sector is involved, let's say Dubai, I don't know if you guys have heard that UAE will be constructing a mall in Jammu Kashmir, in Srinagar, the government of UAE. Good thing. That means they are investing. Let's say any sort of dispute arose that, due to public safety, the land is not available or whatsoever. So the whole dispute, the whole project will go into arbitration. You know what to do. And general public sector projects are huge, huge, huge money. So it's a very emerging field. There's a lot less competition in this. Yeah, one of the main thing is before deciding a career, I would urge you to choose a field in which the competition is less. If the competition is less, there is a more chance that you can reach to the top soon. If you want to be a family lawyer or criminal lawyer, the competition is enormous. It's gigantic. On the other hand, if you want to go into, let's say, investment arbitration, you can name the firms on your one hand who deal in those matters. So no matter what, the client will have to come to you. They will be monopoly. I mean, monopoly is not a good thing, but it will pay you good. You can also go into energy arbitration. Energy like your oil, gas, power. As we know, these things come in huge money making things. There's always construction arbitrations, public sector undertaking. Someone wanted a dam to be built somewhere. The land is not getting acquired. The quality of cement is not good. They'll put in arbitration. The arbitration is worth thousands of crores. You will get a percent out of it. So good money. If you want to go into mediation, I won't recommend you to go for family mediation or custody mediation whatsoever. It will involve your tragic courtroom dramas. But you can go to corporate mediations because in that parties don't have any emotions. It's just that they have a dispute. They want to get it resolved as soon as possible so that they can go back to doing business. Like let's say if Pepsi has a dispute with someone who sells them plastic bottles, for to pour the Pepsi in. Sorry. Uh, Pepsi has a dispute with their plastic manufacturer who provides them the bottles. Over, let's say, the price of a bottle they were buying at 1 paisa per bottle. Now they are asking to be 1.5 paisa per bottle, whatsoever. So what both of them want is that this dispute to get over so they can get back to business. Because at the end, nothing matters more than money. If you want to make a career in any field, you should always follow the money. I mean, if you are rich and if you want to live a fulfilling life, totally up to you. But I would suggest that in corporate mediations, you can make good money. And again, you will get things done. In arbitration, there are delays. In litigation, there are delays, but mediations are pretty much over quickly. So yeah, that's from my side. I'll see the questions now. It's already over 4. I'm pretty sure you must have important things to do, everyone. Tamanna, you asked, how can someone be a panelist mediator, specifically arbitrator, specifically mediator as corporate lawyers? Can we practice as mediators along with working at law firm? See, Tamanna, that totally depends upon the law firm you're working at, and then at the leverage, the sort of leverage you have. Let's say if you're a big hotshot mediator, the entire country knows your name. You are a pretty big person. Then you can do mediations as well and work in a law firm as well. But let's say if you are just, you just received your 40-hour mediation training, you just graduated, you go to a law firm, your law firm would not specifically have a problem with you doing mediation, but for mediation you will have to take up your time, 3 hours, 4 hours out of your busy schedule in a firm, and I don't think your firm would like to afford giving you that break. Further, your firm can stop you for doing mediations. Let's say if ABC is a client of your firm and you get empaneled as mediator in the same dispute, so your firm can ask you to step back. So you can practice mediations working with law firm, but it's not practical per se. I hope I have answered your question. uh, okay, I hope you answered quite some time. The mediation bill has visitor time limit of 180 days to complete the Ayushi, your question is that considered by the court of review. See, mediations and arbitrations are 100% party specific. If parties want to complete in 180 days, it will complete in 180 days. If parties want to give extension, parties will get extension. Because parties are the one who are paying, they are the supreme. At the end, as I said, money always matters. Where are you getting your money? If parties are paying, good for you. Oh, you have another part. The party pays to attend this first. No. See, you see what happens is if a mediation is failed, the mediator will just this will happen. Let's suppose if there's a dispute between two parties, the judge refers the party to mediation. All right. The parties, as for your question, the parties just does not show up or does not participate in mediation. The mediator will just tell the judge that mediation failed. That's it. Why failed? Who was the person at fault? Nothing as such. Because mediations are inherently confidential. Anything even said by parties is, inadmissible in court. It's everything is confidential. So as you asked that it won't determine cost in any proceeding whatsoever. I asked Devika's question, how do you gain experience in the ADR field? What kind of extracurriculars and internship? Well, experience in ADR field, you can participate in competitions, mediation competition, such as the one you guys are yourself organizing. You guys can do, well, definitely internships. Even though you're a student, you can still be, hired as tribunal secretaries. So you can look into that field. Now the thing is, how will you get appointments of tribunal secretary? Raman, I'll get you a question. Now, one thing I want every one of you to listen carefully and pay full mind to it. Networking. Do anyone of you know what networking is? Hand raise, please. Devika is a smart one. Nice. Okay. So I'll assume that not most of you know what networking is. Networking is basically, uh, I guess you guys are in second years. So see, now let's say you are hell bent that you do want to go into arbitration, or you know that you want to go into corporate field. You know you want to go into insolvency field. You know you want to go into IPR field. Basically, you will start going to conferences. You will start going to seminars of your field, not other field, your field. You will stay focused on it. You will see, who are the most influential people are in your field. Who has made a name for themselves in your field. Sorry. You get to know them. You talk to them. Sort of you try to be friends with them so that if they have any opportunity coming up, they will think of you. You know, let's say, okay, who's the most famous person in arbitration? Do you guys want to write any names? Please tell me the name of one famous person in arbitration. Tariq Khan. Yes, yes, yes. So I'll tell you what Tariq does is he goes to all the conferences. He does not attend conferences. He just, goes to conference and, uh, near the dining or networking area. He just stands, people come, they'll introduce themselves to him, they'll meet, they'll exchange numbers, and that's how you become famous because now everyone knows you. So what happens is, you know, Tariq runs IEMC. You go to him, you meet, you say that, hello, sir, I am this year law student from this university, and I have interest in arbitration. If you have any opportunity coming up, do let me know. You have to be very sweet with them. Then you can you can stay touch you can stay touch with him. He regularly posts blogs, etc. Whatsoever. He goes to judge uh, competition. You can try to stay in touch with him. If you see his blog, you can read it. Then you can drop him a message over LinkedIn or anything. That sir, I read your blog. It was amazing. Or if you want to give you some suggestion that you should have mentioned this thing, that thing. So what happens is they will recognize you, people, and if you go personally meet him, he will again introduce you to two or three more people because he is a famous person. He's never standing alone. You go meet him, you talk about yourself, then he will introduce you to two or three more people. Then you talk with them. It's like multi-level marketing, but better. So that's how you do networking. Now, as I said, he runs IAMC. You can always reach out to him that, sir, I'm interested in tribunal secretary positions. If there's any arbitration proceedings going on, if there's any arbitration tribunal, please give me an opportunity. Maybe he'll give, maybe he won't. But what's the harm in asking? Maybe in future, he would be looking for someone in, maybe he'll be looking for some tribunal secretaries, and maybe he's not finding anyone. Then he'll remember that, this and this person asked me, so I can ask them. So networking will open the doors for you. Your academics can never. If let's say, you know, if you are applying for a job, again, let's say at IAMC, and there are two people in consideration. One is, let's say, you guy, one is you, and the other person is from, let's say, NLS Bangalore. Who do you think will get the job? The chances are the NLS guy. But if Tariq Khan personally knows you, then you will have better chances. So that's networking in a nutshell. That means you have to know people in your field. That's why I said that you have to determine your field in early law school, what you want to do, where you want to go, and then start meeting people and start interacting with them. So that the time you graduate, basically everyone has heard of your name. You know, as we say in Hindi, naam chalta hai. We have to do that. Naam chalana apna. Ayushi Sodik Kirmani. Sorry, Ayushi, I have not heard. Rais have two questions. What are the key benefits and drawbacks of using ADR compared to traditional litigation? What is the success rate of ADR in resolving disputes? Rais, benefits I'm pretty sure I've covered in the first part. I would love to repeat, but we are already very over time. Drawbacks, I don't see any, except that it's very expensive. And sometimes the parties, whenever a party lose any arbitration, they just go for setting aside a order, and then you go for setting aside in court, then eventually you have to end up in court only. Either way, if the other party is doing in good faith, again it all depends. And the success rate for mediation is actually high as compared to arbitration, because mediation both the parties come to a conclusion of their choosing. In arbitration, the arbitrator decides what's good for them. I hope I have answered your questions, and we are very over time. I think I'm not going to complete my notes, but either way, you guys can always reach out to me on LinkedIn. I am pretty much always active on LinkedIn. I love to talk to people. So, any questions, anything whatsoever, please, reach out to me. I'll be always there to help you out. Oh, sorry, I missed Raman. Wait, sir, I'm in 12th class. Is it compulsory to join analysis for it? Raman, you are very young for this sort of question, I think. But again, NLUs have that sort of, what do we say, the brand. But I don't think that you need to definitely join into an NLU for arbitration or mediation. People generally go to NLUs for corporate law. It's what I believe, because corporate law firms do on-campus hiring based on majorly corporate laws, your company's laws, your insolvency, bankruptcy, maybe dispute resolution too. But don't limit yourself. Don't just say that it's either NLU or nothing. Always keep your options open. You can do whatever you want in your life. No worries at all. I've seen people 60 years of age enrolling themselves into law schools. 60 years of age. So there's, don't worry yourself about these things. I hope that you like my answer. And again, last, if any of you has any other questions, please reach out to me. I'm always available. Thank you so much. I've taken up a lot of your time. Thank you.
Thank you so much, sir. It was indeed a very insightful session. You covered all the concepts very patiently, and till the end of the session, it was quite interactive. People enjoyed the session a lot. Ankita would take over from here to give a vote of thanks.
Thank you so much, sir, and thank you everybody for joining this session. I hope it was valuable. And because for me personally, as a second year student, student, it was a very insightful session, because I'm extremely thankful that how sir realistically told us that how your interests feel are more important, and how realistic sir told us that money matters and these career choices are important, and these options must be considered in your career choices. Sir told us about different type of mediation and arbitration versus mediation. So there are a lot of things which are more clarified, which are more in a very formulated manner in my mind, and I hope that it was for everybody. Sir, you helped us a lot with the ADR and all the confusion that was created. So it is very simplified now, and we are very thankful for this session. We will always be thankful for this. Thank you, sir.
Thank you so much, Ankita. It was a pleasure to me. I will
Thank
hopefully
you.
be in CNLU next month. So if any of you want to meet, I'll be there. Drop me a message. All right. Thank you. Have a good day. Bye bye.
Thank you,
Enjoy
sir.
your weekend.